いします。
Hi, welcome to Tozen Daigaku. This is December 20th, 2020. Today's Tozen Daigaku will be on YUKI MUKI and job security. I should say it's actually YUKI MUKI. The U is long and the mu is short. Okay, so basically what this is about is how employment works in Japan in the sense of job security. And some jobs don't have much job security and some do. So I'd like to start by sharing a, let me see if I can do this. I'll be careful. Okay. So I think you should be able to see this. It says Tozen Daigaku, Yuki Muki, and job security. In Japanese, it's Yuki Koyo and Muki Koyo. So if you see down here a little bit, Yuki Koyo is fixed term or temporary employment. What this means is that it has a start date and an end date. And the most common of this is, say, like a one-year contract. And often these contracts revolve. So 1 year and 1 year and 1 year. That's probably the most common term. But it could be anything. It could be 1 month. It could be 3 months. It could be up to 3 years. Now, the other type is called Muki Koyo. This is open-ended or permanent employment. And this is where you get job security. And we'll talk a lot about that a little bit later. So these are the two types. So when you're in a job, there's many things you should try to find out about your job. First of all, who is your employer? And surprisingly, that's actually sometimes difficult. And another thing is, are you actually employed or is it a services contract, like an independent services provider contract, what's called Gyomu Itaku. And then if you know for sure you're on an employment contract, then if you have a written contract, it's pretty easy. Look at your contract and is there an end date or is there not an end date? And if there's no end date, the default position is Muki Koyo, or open-ended permanent employment. And that means, basically what that means is you have to have a good reason to be fired. You can't just be fired because, just because the boss doesn't like you or something like that. So, okay, let's start. I'm going to go in more detail. Let's start with Yuki Koyo. And I wrote here, management has all the power. And that's really true because let's say you have a 1-year contract. During the contract, the management needs a good reason. Your boss needs a good reason to fire you. But once the contract is over, the boss needs no reason to not renew you after that. The end of the contract is the end of your employment. And this is really important to understand. If you have a contract with an end date, your job is a temporary job. And you have almost no rights at the end of the contract. And this is something why we fight at Tozen Union, why we fight for Muki Koyo, because it's very easy for management to abuse their authority when you're in a contract that ends. So there's nothing good about Yuki Koyo for the worker. And some people kind of sense that, okay, you have less commitment to management, but even if you're on a permanent contract, you can still resign when you want to resign. It doesn't mean you have to work until retirement at that company. You have the freedom to resign. It's that management cannot easily fire you. So Yuki Koyo, whatever anyone tells you, especially if management tells you, it's not good for the worker. There's nothing good for it. There's nothing good about it for the employee. Okay, now there's certain theories about Yuki Koyo, about what they mean under Japanese law. And these are kind of like legal scholars have discussed these 3 theories about, what are your rights at the end of the contract. And so the first one is what I just talked about, keiyaku shūryō setsu. And what this means is, it's called in English, contract termination theory. And what this means is at the end of the contract, that's it, period. You have no rights, no claim, nothing. And this is the most extreme of the 3 theories. Unfortunately, it's pretty prevalent, and many of the courts take a view pretty close to this one. So it's very important to understand this one. The second one is tenkasetsu, or contract transformation theory. And what this one says is that, okay, let's say you have a one-year contract. At the end of the one-year contract, you have no rights because it's temporary. But then let's say you renew it again and again and again for this one-year contract, and you build up many renewals over many years. In this case, the contract transforms into what is effectively a permanent contract. And I'll talk about specific cases where this has been used. But that's the idea, is that, okay, maybe one time you don't have any foot in the door in terms of job security, but if you're renewed over and over again, it's kind of ridiculous that the contract is temporary in the first place. So in effect, you've been transformed into a permanent contract. And this is one of the purposes of this is to avoid what's called permanent temp in the United States. In the United States, there was a famous case of Microsoft had many employees on temporary contracts, and they just renewed them, basically to avoid them ever getting real rights to the job. And they sued and they won. And basically, it was considered like abuse of this permatemp status, permanently temporary. So that's tenkasetsu, is the idea that over time you start to transform into something more permanent. Okay, number 3 is jōtaisetsu. And this is directly translated as contract circumstances theory. And what this says is that if the circumstances of your employment are such that the employment is in effect permanent, kind of like the other one, but it doesn't really matter how many times you were renewed. But even if the contract says it's fixed term, if the circumstances are such that in effect you're permanent, then management must have a good reason to dismiss you. So remember that in Japan, dismissing someone, you have to have a really good reason to dismiss an employee. So this jōtaisetsu says basically, even if it says you're 1 year on your contract, if the reality of the situation is that you're permanent, then the employer cannot easily non-renew your contract. Okay, so this is something where the renewal, one of the examples of this is if the renewal process is nothing but a formality. Let's say every year your employer just hands you a contract or sends it to your home, and there's no interview, there's no discussion, no appraisal, and you're just kind of automatically renewed. And it's obvious that the temporary nature of the contract is just BS, and they're just, it's only a formality. And so in that case, according to jōtaisetsu, then you should be treated totally as permanent, and the hurdle for dismissal should be very high, just like a regular dismissal. Yeah. Now, some courts use keiyaku shudo setsu, some courts use tenkasetsu, some courts use jōtaisetsu, or they combine them. And I'll go into cases later regarding that one. Okay, now let's talk about MUKI koyo. Now, MUKI koyo, again, is the default position. MUKI koyo is permanent, open-ended employment. Now, the employer can dismiss you if there is good cause, and they need a really good reason. They can't just dismiss you on a whim, or what in some states in the United States, there's employment at will. So basically, they can just dismiss you when they want. Employers, if you're in a MUKI koyo position, which is of course very good for the worker, they can't just dismiss you whenever they want or however they want. On the other hand, you as a worker can resign, and there's certain ways and notices you might have to give or whatever, but you can resign. You're not bound for life to this company just because it's MUKI koyo. It's MUKI for the employer, not for you. Okay, and in this, the hurdle for firing someone is in Article 16 of labor contract law. At first, I just want to read it in Japanese. So, 労働契約法第16条。解雇は客観的に合理的な理由を書き、社会通念上相当であると認められない場合は、その権利を乱用したものとして無効とする。This is the foundation for firing someone in Japan. This is a very important phrase. A lot of important legal principles in there, like goriteki, and I'll explain that in a second. Now, if I just translate this, like without going into detail, I'd say you can't dismiss a permanent employee without a damn good reason. And it really is pretty solid. You have to have a good reason. You can't just not like the person, or you can't just say, well, they don't get along with people, or they have a problem with the pacing of their work or something like that. You need a good reason. Okay, now a more proper translation of Article 16 says, a dismissal lacking objectively reasonable grounds or cause according to social norms is an abuse of the right to dismiss and therefore invalid. So in other words, employers have a right to dismiss you, but they can't just do it whenever they want to. They have to have objectively reasonable grounds and cause according to social norms. And social norms, of course, are social norms in Japan. There's what's considered an acceptable reason and what's considered not acceptable reason. I can give you some of them if you like. One thing I'd like to point out is this word reasonable. I don't know if you see that I highlighted it. This word reasonable is goriteki in Japanese. Goriteki is a really important concept and legal principle in Japan. It's in Japanese law. It's everywhere in so many laws, because the law can't cover every single instance, because human affairs are very complicated and all kinds of things happen, and it's very detailed. So what it comes down to when there's a gray zone is it goriteki or not? Are these grounds goriteki? And the courts will look at the whole case, like, okay, this person was objected for this reason, that reason, this reason, and overall, is it reasonable to fire this person for that reason? And I'd like to talk about a specific case called the Kochi Hoso case. And this is the standard, most famous case of how difficult it is to fire somebody in Japan. And it might be a little bit easier in the ensuing decades since this case happened, but I'd like to talk about, I forget the year, I think it was the 70s. Sorry, I should have put it here. Can you check, please? Yeah. Mizuho is going to check for me. So anyway, so this guy was a radio announcer, and he had his own show in the morning, and the radio station, they had shift workers throughout the night, and he had an early morning show, and he had a very good work history over many years. Yeah, 30日 January 30th, 1977, right? Sorry. Okay. Yeah, okay. So the Supreme Court handed down the verdict on January 31st, 1977. It's what? Oh, sorry, the clickety clack on my keyboard is really loud. Sorry about that. 31st. January 31st, 1977. Now, this announcer had a very good work history and worked for many years, and then he overslept his own radio program, and they couldn't do the program. I don't know what they did, maybe play music or something like that. But and of course, his boss was understandably quite angry about that. And of course, he promised to never let it happen again. And remember, it's his own show. There's nothing they could have done. The broadcast, basically, the radio station could do nothing during that time. 2 weeks later, he did it again. And he also didn't even report it to his boss. So the boss had just had it and said, I can't keep you. You've already overslept twice for your own radio program. I'm going to have to let you go. So he sued, and the court case went from the district court into the High Court, and then all the way up to the Supreme Court. And the Supreme Court said, okay, look, it's, of course, it's terrible that he overslept twice and that he didn't report it the second time, and it was within 2 weeks. But okay, look at his past work history before that. He always worked very seriously, and there were no problems before that. And it's too much to fire someone just for oversleeping the radio program twice. And so this gives you an idea of how difficult it is to fire someone in Japan, because this is not like oversleeping an administrative job or something like this. Because he overslept, they had to cancel the radio program twice. And it was within 2 weeks. So this gives you an idea of how solid, when you're on MUKI Koyo, how solid your employment is. And this is something, of course, very important. People make mistakes. Job security is very important, both for the worker and for society. So this is something that Tozen Union, many of our local unions fight for MUKI Koyo, so that so our members can have job security. Okay. So that gives you an idea of MUKI Koyo. Now, going back to YUKI Koyo. So there's two famous cases in YUKI Koyo, and I'm going to go over them in a second. Sorry. Article 19, right? Okay. So the most famous cases are Toshiba Yanagicho factory case and Hitachi medical case. Okay, let me start with the Toshiba Yanagicho factory case. Yeah, and these two cases are about workers who were non-renewed. And again, if you're on YUKI Koyo, if you're on a fixed term contract, you have much, much less job security, because at the end of the contract, basically that's it. Although there are exceptions, and I'll talk about them now. In the Toshiba Yanagicho factory case, what the court basically decided was that because of repeated renewals, the renewal process was just a formality analogous to a dismissal because they were effectively permanent. Okay, so even though the contract said it was a fixed term contract, in effect, the renewals were just automatic, basically. And this is, of the three theories, this is the Jotai Setsu. I'm going to go back to show you the Jotai Setsu, the contract circumstances theory. So the legal principle of abuse of the right to dismiss applies if the employment is in effect permanent. Okay, so let's go back and look at the details of this case. And the Supreme Court handed down the verdict on July 22nd, 1974. There were 7 plaintiffs working on 2 months contracts at the Toshiba Yanagicho plant. One of the 7 plaintiffs had been renewed 23 times. Now, management non-renewed these 7 plaintiffs for various reasons. Some were poor performance. One was for falsifying their resume, and others for economic reasons. They had to downsize. Okay, and so they sued for reinstatement. Now, the first court to take the case was Yokohama District Court. They ruled in 1965 that whereas the original contract term was fixed, their jobs had already lost any semblance of temporary employment and had turned into permanent positions, thereby adopting the Tenkasetsu tenet. The judge also reinstated 5 of the 7. Okay, so basically, they were basically permanent, and of the 7, 5 of them, there weren't sufficient grounds to fire them. So 5 of them actually won their jobs back. In 1970, the Tokyo High Court and then the Supreme Court upheld the lower court's verdict, but the Supreme Court switched the justification to Jotai Setsu. Okay, remember that's the overall circumstances made them in effect permanent. Okay, so this was the Toshiba Yanagi factory case, the Toshiba Yanagicho case was basically that even though the contract said temporary, the job was effectively permanent. Now, the Hitachi medical case didn't go that far. It didn't say that the contracts had become permanent in effect. What it said was that even though they had not become effectively permanent, there was a reasonable expectation of renewal. This kitai. Kitai is expectation, right? So this is a key concept in the Hitachi medical case is about expectation, not effectively permanent. Okay, and this is the plaintiff was X. He worked 20 days in 1970, and then after that, again, 2 months contracts, just like the other case, and it was renewed 5 times. In October 1971, X was fired for economic reasons, so like downsizing. What the court said was X was not effectively permanent, but X had good reason to expect renewal. Okay, so therefore, you can't just fire X for no reason at all. You have to have a good reason. You have to have, remember the, let me go back to the reasons for dismissal. Objectively reasonable grounds or cause according to social norms. Okay, now, if it's just expectation, the hurdle is not quite as high as dismissal. You don't need to have such a strong reason, because the fact that it's just expectation and not effectively permanent gives the employer a little bit more latitude to fire even without that really high standard. And in this case, the Supreme Court found that there was good reason, there was a need to downsize. And so they did not get their jobs back. So actually the employees lost the case. Okay, so just to wrap up, the Toshiba Yanagicho factory case is about temporary employment becoming effectively permanent. And the Hitachi medical case is about if there's expectation of renewal, then you have to have a decent reason to fire the employee. Okay, now these 2 cases, for a long time, they were just case law. And then a few years back, I'm gonna type a little bit, so sorry about the clickety clack. Act, actually. So a few years back, this was incorporated into Labor Contract Act Article 9, which says that if there's expectation for renewal, then you need to have that good reason, objective, reasonable grounds according to social norms. So this is what happens in Japan often, is that case law often becomes the law, especially if it's like repeated over and over and over again. These were precedent for many other cases that were based on them, these 2 cases. So eventually they became enshrined in labor contract law. And so that's a good thing. So, but it's good to have that background to know how it has evolved over the years. Okay, so now I want to talk about, well, what if you're in a temporary contract? Are you just screwed because, you know, at the end of the contract, you have no rights and then your boss can fire you for any reason they want? Well, the one thing that was also put in back in the law changed in 2013 is Article 18 of Labor Contract Act. And let me put that here. Article 18 of Labor Contract Act, or Rodo Keiyaku Hodai 18, includes it's the 5-year rule. And what is the 5-year rule? The 5-year rule says that if you're in a temporary contract and it's renewed and renewed and renewed, if you go past 5 years, you can make yourself permanent. You can convert yourself into a permanent employee, which gives you more job security, which prevents your boss from firing you for no good reason. And of course, we at Tozen Union have been using this as much as we can. Now, I want to go through the details of that because it's very, very important. So I'm going to switch screens. Let me see if I have it here. Can you see that, Mizu? Yeah. Right now, I switched to the flyer for 5-year-old. Okay. Okay, just to make sure. Okay, so this is a 5-year rule. Now, if you look at this poster, we made this little poster to give an idea of how it works. So again, the most common fixed term contract is a 1-year contract. So let's say you start on a 1-year contract. You see this little green thing on the top line going across. And then you work for 5 years, 1 year, 1 year, 1 year, 1 year, 1 year. You're renewed, let's say 4 times. So at the end of 5 years, you've worked a full 5 years. Now, 5 years is not enough. Despite it being called the 5-year rule, it has to go beyond 5 years. So exactly 5 years is not enough. So be very careful, because some really evil employers might try to non-renew you after 5 years, because they know you don't have the right to convert until 5 years and 1 day, 5 years and 1 minute. 1 minute of employment after 5 years, and you can convert to permanent employment. Okay, so after the 5 little light green arrows here, you see there's an orange arrow. It says 1 year, and it says if you apply for conversion here in the little bubble beneath the 2 people, this is this person's 6th year. During this 6th year, even the first day of the 6th year, you can apply to convert your employment to permanent. And once you apply, the law says the employer must accept it. It's just automatically accepted. Even if your employer doesn't respond, it doesn't matter. It's automatically accepted as your permanent. So during that 6th year, you can convert, but you don't become permanent until the next contract. So you don't become permanent until this big orange arrow. So in effect, in this case, your 7th year, because it's 1-year contracts, the 5-year rule makes you officially permanent in your 7th year. Okay, but during the 6th year, if you convert, once you convert, it's as if you've already signed a contract beginning the next year. So you're already good. Like in the 6th year, when you convert, they can't just non-renew you at the end of that year. You know, once you convert, you have a permanent contract that officially begins the next year. So effectively, you're already permanent, but it's just not official yet. Okay. And the main principle behind the 5-year rules is at the same conditions you had when you converted. Now, there are exceptions, and there are dangerous exceptions, is in that if management stipulates in the work rules what's called shugyo kisoku, if they stipulate different conditions, then in some cases they can change your conditions, but it has to be goriteki and reasonable. And the courts haven't really, I haven't seen any court cases yet that go into detail about what is acceptable as a change. In principle, it must be the same conditions that you had when you converted. So if you have like, if you're getting, let's say 200,000 yen a month, all these years, and then you convert, they can't say, well, from next year you get minimum wage. But they can make some changes, and we'll see how the courts rule on stuff like that. It's important that when you, first of all, it's important that you and your coworkers know about this. This is the Japanese version. We can send you this form, which has the information, also has a form that we use. And you can make your own form, and the Ministry of Health, Labor, and Welfare also has a form like that to use. So please feel free to contact us, and make sure all your employees, all your coworkers know about this. And when you apply for a conversion, make sure you have a record that you converted. So if you could attach it to an email or something like that, like fill it in, scan it, attach it to an email, or send it registered mail or something like that. And so whether or not they respond, you have converted yourself. So, okay, so that's basically it for me. And I guess I'll take questions. So can you ask people to ask questions? Mm-hmm. It's okay. It's okay.
じゃあ私、
You want to sit here?
あります。大丈夫です。ちょっと質問です。日本語ですいません。
That's okay. They can hear you, right?
多分仕事契約自体が、知り合いから紹介された仕事だったとして、ちょっと長いんです。通訳お願いします。
Okay, so it was a contract through an introduction with an acquaintance.
で、面接をした際に、文書での、書面での雇用契約が渡されなかったとして、で、口頭だけの、時給がいくらですよっていうだけの、契約だったとして、で、文書でないので、雇用期間がいつからいつまでかっていうのがなんか業務委託なのか、雇用関係があるのかっていうのも、わからないものだったとします。で、一応有給を申請したら降りたので雇用関係はあるとは思うんですけど、でさっき言ってたように常に何でしょう、自動更新、契約が自動更新されるっていうものであれば、万が一合理的な理由なく雇い止めされたとしても、今までこうやって自動更新されてたじゃないですかっていうふうに戦えると思うんですけど。
Okay, so let me catch up. So it was nothing but a verbal contract. There was no written contract, and so this person doesn't know the term of the contract or the status, whether it's employment or Gyomitaku service provider, individual services provider, and but this person got paid leave, so they think it's employment. And then, so what if after it seems that it was automatically renewed? Did they automatically renewed? So they did know the term after a while, or was it?
質問としては、その人のように、例えば1年契約だったとしたら、何年か働いてて、でも急に雇い止めされて、今までこうやって更新できてたじゃないですかっていうふうに期間が分かれば戦えると思うんですけど、その人のように期間が分からない場合、どこからが自動更新されてたのかが分からない場合っていうのは、
So if the person doesn't know the term, but it seems like they were renewed many times and then all of a sudden non-renewed, but if they don't know the term, then how would they be able to fight that and be able to claim, hey, I was renewed many times, right? Is that the question? Okay, so the first thing is about verbal contracts. Let me explain about that. A verbal contract is as legally binding as a written contract. It's just harder to prove. And if there's any dispute, it gets very tricky. And there's certain ways that the courts will establish what was the contract. If both sides agree to the terms of the verbal contract or the verbal agreement, then there's no problem. But if one side says, no, and the other side says yes, let's say I say that, the boss promised me 300,000 yen a month, and the boss said, no, it's 200,000 yen a month. So you have a discrepancy, right? So there's different ways that you can look to find out what the terms were. One is, what did they pay all this time? If the boss is paying 300,000 yen a month all this time, they can't really say now that, I only promised 200,000 yen, but I accidentally paid 300,000 yen, 10 months in a row or something like that. That's one thing. As far as the term, if there's no way to know the term, then it's permanent. In effect, if there's no stated term, either verbally or written, then it's permanent. Now, if it's really obvious, like everybody is on a 6-month contract and they just forgot to say the term for this person, sometimes they can claim that it's temporary. But if there's no discussion of term, this happens a lot like in restaurants where someone will just be hired or something like that. In a restaurant, if there's no stated term, it's permanent. And if it's permanent, then there can't be a non-renewal. They can't say after 6 years, well, actually all this time I've been thinking of it as a 1-year contract. Unless there's good reason to say that, they can't just say that and say, oh, now I'm not renewing you, right? So I would say the default position, of course, is permanent. The employer must show a reason. They have the burden of proof to show that the contract is fixed term, not permanent. The standard is permanent. Does that answer your question?
Yeah.
Any other questions?
Do you see comment?
Yeah, her computer.
I broke my computer.
We've got another question.
Yes, please.
What impact do you think COVID-19 will have on the viability of Article 19 cases? Will courts be more or less sympathetic to non-renewed workers if the employer's rationale for non-renewal on economic problems related to rationale for non-renewal is
Yeah, my fear is that courts will sympathize more with the employer than with the worker, unfortunately. Now, there are some caveats. If the employer is getting aid under the payroll protection program or kochokin, then they're not supposed to fire people just for economic cause, or if they do, they get a lot less money during this basically this year. However, in a normal case, like I do see a lot of employers non-renewing people more than usual, and like even if let's say you work at a school or something like that, and normally there is great expectation to renew. Unfortunately, with COVID, it would dampen the expectation, and I think courts will think that you had less expectation to be renewed during Corona. Now, I think that's illegitimate, and I think that the court should also look, if not more, look at the damage that it could cause the livelihood of the worker, and they should place a higher hurdle on the employer to non-renew. However, my concern is that it'll be easier for employers to get rid of excess employees that they have because their business has shrank or something like that. Even if they don't call it an economic downsizing, that courts will certainly take this as a factor, and the companies are under a lot of stress and all that. So that's my concern. Hope I answered that. Or anything? Oh, okay. No other questions? Okay.
はい。もし合理的ではない、理由で、雇い止め、解雇ですね。これ受けた場合、労働者はどういうふうに戦ったらいいですか？誰か聞いた？
Okay, so if somebody, let's say a worker is fired or non-renewed for a non-reasonable reason, what can they do to fight? Well, I'd say it's too late. No, okay, that's a little extreme, but the thing is, before you get fired unreasonably, please unionize your workplace. If you're not already in a union, join a union, get your colleagues to join a union. Because if you're not in a union, basically the only way you can fight is to go to court, and court is expensive and takes a long time, which of course you can do. And the thing about court is it's a huge roll of the dice. If you win all the back wages of the time of the years you were in court, which can take 2 or 3 years easily. And if you lose, you get nothing. So it's a huge gamble in that sense. So the best way to prevent it is to build a strong union at your workplace and prepare and defend against your employer, abusing the right to dismiss. Now, ironically, unionizing might draw more attention to you and make it more likely you get dismissed. So, of course, you have to keep that in mind and do it strategically. And, of course, if you're in Tozen Union, our organizers will help you go through that. It's very hard to, you can't unionize after you get fired. It's almost impossible because, it's just too late. You have to be prepared to how to deal with these things and how to prevent it and stuff like that. So once you get fired, basically your main option is to go to court. there are no government agencies that judge whether a dismissal is just or unjust, other than the courts. Now, the exception is if it's based on discrimination, like gender discrimination, there is an office that enforces Equal Employment Opportunity Act. And if it's based on union activities, let's say you're fired or non-renewed because of union activities or because of striking, there is a labor commission which will adjudicate in those cases. But if it's not some kind of specific discrimination, the only redress can be found in court.
First question. Can you move the microphone away from?
Oh, sorry, was I clicking?
Yeah, it's really loud and then you've moved.
Sorry.
Is it the same with Gyomu Taku contracts? Can someone apply for a permanent contract when they've reached that stage of 5 years?
No. Gyomu Taku is not considered employment at all. So the only right you might have under Gyomu Taku, this is like individual service providers, is trade union law. Now, it might be that the contract says Gyomu Itaku, but in reality, you're actually an employee. And in those cases, then yes, the 5-year rule applies. But first, you have to prove that you're an employee, even though it says Gyomu Itaku. And there are many ways to that. And there's a checklist. And I think, have we done a Gyomu Itaku Tozen Daigaku? We have, right?
No,
Giso Ukeoi. Yeah, so we've done something like that. Maybe we should, in the future, do a Gyomu Itaku Tozen Daigaku. But the short answer is the 5-year rule does not apply unless you're an employee with an employment relationship.
And the second question, are there the start of it was nice suit.
Thank you.
And then the main point was, are there differences between part-time and full-time?
Yeah, that's a good question. Sometimes people confuse part-time, full-time versus temporary, permanent. And I think the reason is because usually permanent contracts are with full-time employees, but there's no rule about that. There are part-time employees who are permanent. And especially since the 5-year rule came about, we're seeing a lot more of them. So it's very important to distinguish how many hours a week you work versus how long the duration of your employment is. And in terms of part-time, full-time, there's no legal definition of part-time and full-time except for certain laws and certain benefits. In general, the 5-year rule and the permanent and temporary status has no relevance to whether you work 10 hours a week or 40 hours a week. So yes, you can convert even if you work 1 hour a week, you can convert to permanent after 5 years. Anybody else have any questions? We're going to throw this up on the web, of course, right, tonight, so it'll be available for everybody.
Can we do the reminder about the pr.tozen?
で、ちょっと今日これで質問ないみたいなので終わるんですけど、今年1年間、2月からなんですけど、東ゼン大学1年間、やってきました。
We've done Tozen Daigaku for a year since February.
はい。で、来年も引き続き毎月やっていきたいと思うんですけど。
Next year we want to do it every month again.
はい。で、ちょっと今皆さんにもちろん当然の組合員の方たちにも、来年どういった講義をやってほしいかみたいなことを今聞いている最中です。
We've asked all the members in Tozen what kind of Tozen Daigaku they want to see.
はい。で、当然の組合員の方でない方たちも、どういうものが見たいかっていうのを、リクエストいただきたいので。
And of course, we want requests from non-members as well.
今この、何でしたっけ、YouTube の配信の 概要欄に、PR チーム、当然 PR っていうE メールアドレスが書いてあると思います。
In the comment section under this YouTube live stream, we put the address of Tozen's PR team.
はい、でそこにぜひどういう講義を今後してもらいたいかっていうことをメールいただけると、今後の参考にさせていただきます。
So please send an email with what kind of topics you want us to cover, and we'll keep that in mind as we set up the schedule for next year.
全部が全部できるかっていうとちょっと難しいと思うんですけど、
I can't guarantee we'll use all the suggestions, but
参考にさせていただきます。
But we will keep them in mind.
あとリクエストだけでなくても感想だとかこうした方がいいんじゃないかっていうフィードバックみたいなこともいただけると助かります。
And not just requests, but also we'd love to get your feedback or criticisms or things you think we should change. So.
よろしくお願いします。今年1年本当にありがとうございました。
Thank you very much for this year.
はい、来年はもっとちょっとクオリティを上げていこうと思うので、よろしくお願いします。
We're going to try to beef up the quality next year, so
はい、
thank you very much.
はい、ありがとうございます。またすぐ良いお年を。来年の予定もすぐ立てたら、ウェブサイトに更新するので、ぜひチェックしてください。
So as soon as we have the schedule for next year, we'll put it up on the website, so please check it out.
はい、では今年1年ありがとうございました。
Thank you very much for this year.
良いお年を。
Happy New Year.
ちょっと待って、今終わらせ。
So that.